my view now is, and the plaintiff's view in this application is, that times have changed. 35 years later, it's absolutely obvious now that the government is very much involved in universities.
Welcome to episode 11 in the second season of Justice Center Weekly, a podcast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with us today is lawyer Glenn Blackett. The question we're dealing with today, generally speaking, does the Charter of Rights and Freedoms apply to universities in British Columbia? We know the Charter applies to governments of all levels in Canada, but does that include post-secondary institutions? That question has already been dealt with in one province, but because that one province has come to a decision, that doesn't necessarily set a precedent for the whole country. So what is the status quo in BC? It's been said by people like Justice Center President John Carpe that sooner or later the Supreme Court of Canada will eventually have to step in and deal with the issue to settle the matter for the whole country. Now, Glenn, why don't you introduce the case and explain how it touches on this issue?
Okay, thanks very much for having me, Kevin. So the case that I'm dealing with next week in the BC Supreme Court is a claim by three BC students, or former BC students, Noah Alter, Jared Yeager, Cooper Asp, and a club that they formed called the Free Speech Club at the University of British Columbia. And effectively, the basic facts are that in 2019, they had hosted a couple of events that started to get somewhat unruly because of interference by groups like Antifa. They were hosting speakers that had controversial views on things, not leftist views on things. And therefore, Antifa and a group called Students Against Bigotry and others decided to take it into their own hands, mete out some vigilante justice, and do what they could to cancel the talks through force. And literal force. There were police forces there present. There was doors being blocked. There were people being pushed and shoved, fire alarms pulled. All the usual shenanigans. Disappointingly, and I don't pretend to know exactly what the university did in response, but it appears to me and my clients that they didn't do anything. They just let these students run roughshod over academic freedom and over freedom of speech, and effectively, attempt to shut these events down. This sets the stage for the facts that come along in the end of 2019, where faced with this, this lawless group that's trying to cancel free speech on a university campus, the Free Speech Club and these students plan an event involving Andy Ngo. And Andy Ngo is a Portland-based journalist. I think he writes primarily for the Post-Millennial right now. And his basic beat is Antifa. So he knows a lot about Antifa. He knows the individuals, he knows the operations, he knows all sorts of stuff. So they wanted to bring him up and have him talk about the dangers of Antifa. And of course, shedding light on the topic of Antifa isn't a very popular thing for Antifa to see happen, or leftists generally. So there was a lot of chatter before this talk went ahead among, this student group in UBC called Students Against Bigotry, I would say ironically named, and others suggesting that the talk should again be canceled. They talked about throwing milkshakes onto Andy Ngo, blocking traffic so he couldn't get to the event, this kind of stuff they had threatened. Maybe a bigger player, though, was a group called the Vancouver Labor Congress or something like that. I'm guessing a leftist political organization. They wrote to the president, Santa Ono of UBC, and they said that Andy Ngo basically has the wrong politics. They called him alt-right, which he's not. I mean, anything these days that isn't alt-left is alt-right. So I guess by those parameters, he's alt-right, but he's no alt-right guy. I think he may be homosexual. He probably would call himself a liberal. In any case, this group contacted the president and said that this guy's got the wrong politics and said that you should suppress this free speech on campus and cancel the event. The president's first move was to contact his, I believe his first move was to contact his DEI representative. And then he spoke to, basically went through security, and there was some conversation about whether or not, the proper security protocols had been passed for this event. And lo and behold, the university decided shortly thereafter that the event should be canceled on security concerns. And so in making that decision, so far as we can tell at this point, the university decided to cancel the event to protect what they say was the psychological safety of students. So, the whole campus is a free speech for leftism, I suppose. And also, when they made the decision to cancel, they didn't even consider the fact that one of the university's core mandates is to allow people to talk about things. So they just went ahead and canceled it. And our claim now is that the University of British Columbia, violated a number of legal rights, and most importantly for our present conversation, that they violated the students and the free speech club's rights for freedom of expression and freedom of assembly, freedom to get together and talk, that are guaranteed under the Charter of Rights and Freedoms.
Okay, so what stage are we at now? You say it's at the BC Supreme Court. Are we going through some kind of appeal, or are we at...
Yeah, we're going through an unfortunate procedural dance at the moment. We originally filed the matter as a petition, which is sort of a judicial review. It's kind of a short form way for the court to take a look at the way legal statutory rights have been operated by a statutory delegate. We've decided that we're going to move it to a civil claim, which is a kind of standard lawsuit. And so we're in the process of migrating it over to a civil claim. And the thing that brings me to court next week is the Crown, the BC government, has brought an application to strike the claim against them because they say that universities are charter-free zones. And even if the charter applies, why should the government have any liability for students having their charter rights trampled?
Oh, okay. How would you counter that argument?
That the case law demonstrates that they have liability.
Okay. Well,
Yeah.
Okay, they have liability because it is a charter-free zone? Or because it's not a charter-free?
No, I mean, okay, right,
Yeah.
sorry. I thought you meant the second part. To counter it, I mean, so in their defense, in the 1990s, so this would be 8 years after the charter was originally enacted. The court looked at whether or not the charter ought to apply to universities. And I mean, it's basically the charter applies to the government. The idea is that the Charter of Rights and Freedoms does not allow the government to infringe certain freedoms. So the government can't, censor you. The government can't jail you for no reason. The government can't whatever. But because we live in this new quasi-socialist paradise where the government has its fingers in every pot, the dividing line between what's government and what's not government is not very clear. And so in order for the charter to apply, you need to be able to demonstrate that it applies, that you're dealing with an entity that is somehow governmental, or is delivering a government program. And so in the 1990s, this is now almost 35 years ago, the Supreme Court looked at, okay, well, is a university in a situation where its operations ought to be subject to the charter? And actually it looked at the more distinct question of whether or not the university is government. So is it government per se? Is it is it a legislature, but rather, is it a part of government? An agency of some sort. And the court at that time basically hearkened back to the history of the university institution and said, ultimately this is an institution that is a community of scholars that is independent of government. And in the 1990, the court said basically on the facts before them that there wasn't enough of a government influence over what was happening there to call it government. So, the upshot of that seems to be that, well, then the charter doesn't apply to universities. But that's a bit of a simplification. The way that cases work, what it means is that charters didn't apply to the universities in those cases based on the facts in those cases. Okay, and there's some legal principles that flow out of those cases that are very important for determining, whether or not a university or any other entity is government. Those cases are very important for understanding where the charter does and doesn't apply. So that was the 1990s, and I certainly would have been making the argument in the 1990s that we were no longer looking at something which is just a community of scholars, and I might have tried to do a better job of presenting a more comprehensive picture of just how involved in the university's governments are, which is not to say that I could have done a better job in those cases, because I'm sure I couldn't. But the applicants didn't do a great job or didn't make much of an effort to demonstrate really all of the different strings that are attached to the government. So my view now is, and the plaintiff's view in this application is, that times have changed. 35 years later, it's absolutely obvious now that the government is very much involved in universities. In BC in particular, and in Alberta, I can't speak to other jurisdictions exactly, but in BC and Alberta, there is, for example, an entire infrastructure which the BC Crown calls the accountability framework, where the BC government has the universities accountable to the government in their delivery of government programs. And so that entire accountability framework is a big exercise of control. And importantly for the case law, it's not some maybe 1 in a million years I'm going to exercise this control, or I exercised the control when I incorporated the university and I haven't since. We're talking about routine and regular control of the universities. And that's a important and bright dividing line between entities that are either sufficiently controlled by government or not. So basically, we're saying that on the facts today, it's pretty obvious that the government controls the University of British Columbia sufficiently so that the charter ought to apply. And we also make other arguments. Another very strong argument is that even if the university is not government because it's controlled by government, the university is delivering a government program, which, I'm sure if you surveyed 90 or 100% of, if you surveyed Canadians, 99% of them would come back and say, sure, university education is a government program. It's a huge part of the budget, right? We have a minister of advanced education, right? The minister of advanced education must have some plans for that education. I mean, if that's not a government program, then what's a government program? So it seems pretty obvious that it's a government program. I don't know how you would splice that hair to say it's not a government program, but in 1998, the Supreme Court came up with a case called Eldridge. And in Eldridge, the court basically said, look, even if you're not a government entity, if you're delivering a government program, in the delivery of that program, you're subject to the charter. And so we're basically saying that, the second argument is that if they're not government, then they're delivering a government program. And then the last argument we have is that if you look at UBC especially, UBC is a city. It's a little city. It's got an elected board. It's got its own utilities. It's got its own thoroughfares. It's got building permits. It's got business regulations. I mean, it operates functionally like a city. It even collects property taxes effectively. So there was a case called Longueuil versus Godbout, or maybe I'm messing that up, Godbout. And in Godbout, the Supreme Court of Canada said a municipal government is a government. And we would say that on the same basis, UBC is a government as well. It operates like a government, looks and smells like a government, so it's a government. So those are the basic arguments we're making.
Education, creature of the province, that kind of thing, under that kind of control, but not necessarily federal, right? It's mostly putting it under provincial control. Is that kind of the connection?
Well, yeah, I mean, we haven't got into the federal control that much, but the university depends on certain sources of funding. One big source of funding is international students, and the federal government has a lot of control over who comes and goes as international students. Another big source of funding for a university is research dollars from the federal government. And the research dollars from the federal government, so far as I know, are all tied to various federal policies, most importantly, DEI policies, diversity, equity, and inclusion. And if you know something about diversity, equity, and inclusion, it has no limits, right?
Okay.
If you as an institution, in order to get government cheese, say, I hereby will comply with diversity, equity, and inclusion, that means diversity, equity, and inclusion in who you hire to teach, who you let in the door that you're going to teach, how you teach them, what you teach them, whether they pass, everything, So I think even though it's not something that we're raising in this application, the fact that there is significant federal government control adds a layer of certainty to the fact that this is a creature of the government, really.
Okay, so that's what I was wondering, the flow of dollars, that doesn't sound like it's part of your argument necessarily, the flow of dollars from federal government.
No, I mean, it's just a smidge, but it's more the flow of dollars, the bigger chunk of dollars is the annual grants that the university gets from the provincial government. So back in 1990, the Supreme Court of Canada was provided with data on the University of Guelph and maybe the University of British Columbia as well. But they found that, the University of Guelph only receives about 80% of its funding, 80% of its operating revenue it gets from the government. And that wasn't enough to clear the hurdle. So a giant number is not, for some reason, sufficient to demonstrate that you have a government entity, which is maybe sensible, but I think the number is maybe a more important factor when looking at whether or not it's delivering a government program. Because if they get all their money from government to do what they're doing, then it seems to me, just undeniable that they're delivering a government program.
Certainly
anyway,
support.
But yeah, the biggest...
It's certainly support for that argument anyway. So the dollar flow, yeah. How about the fact that there's a lot of political connections between deans of various universities and political parties? I've seen that. I remember when Alan Rock got appointed, I think it was the University of Ottawa, after being in the federal Liberal cabinet, he was appointed dean of a university, and that was noted by quite a few, and I have noted a few others. They had connections, not necessarily from the cabinet, but there are a lot of connections between political parties and the heads of universities. Does that factor into your argument at all?
I would say, not for the. I mean, in the present application, not so much. In the bigger picture, it does. The importance of the case, it does. Smaller picture, though, for the purpose of the argument, I think what it shows is, and we haven't raised this issue, I don't really have much details about that, especially with UBC, although I don't doubt it's true. But it shows that universities and government are highly integrated, right? So that high degree of integration suggests to me that they're not a quote community of independent scholars, right? They're a government institution doing governmenty things. But I think that political connection, not so much that, connection to politicians per se, but rather the political persuasion of the university is a serious problem. Okay. And because if you look at, the name escapes me, but I believe it was a study done at the University of Chicago that generated, among other things, a set of principles called the Chicago Principles. And the Chicago Principles is kind of a blue sky, set of principles about what the university is about and how does the university deal with the concept of free speech. And basically, the Chicago Principle says that the university is more or less a neutral institution, which is supposed to facilitate the search for knowledge. And so if it's there to facilitate the search for knowledge, then it, provides a forum for people to speak. It's very, very careful about interfering with speech because that's its mission is to facilitate that search for knowledge, and that search for knowledge requires speech. And yes, there are legal limits to free speech. You can't get up on a pulpit and point at a guy and say, kill him. And there are other limits to free speech, some of which I don't agree with because I'm probably more of a free speech absolutist than some. And so that's all fine and well. But once you have an institution that has a political orientation, which is the natural function of a faculty which is overwhelmingly left, then you cease to have an institution that actually facilitates the search for knowledge. You have an institution that facilitates the reinforcement of a political dogma. Mm-hmm. And so, and this is demonstrated in spades in this case because you have a leftist Labor Congress. I think I didn't look them up, but they called Andy Ngo far right. So I'm guessing that's where they're coming from. But you have a leftist organization contacting a university that I see a lot of leftism in their materials. And really, I don't think with appropriate attention to, their legal obligations, the university cancels it. This is exactly the kind of thing you would expect from an institution that has a political orientation. They're going to censor their political opponents. And so, that's a problem from the university's standpoint because the university is not fulfilling its mission. And it's a problem from Canadians' perspectives because if you're a Canadian like these students that wants to go to university and enjoy a university education where you can actually seek out knowledge, in a forum that permits that, you can't get it at a university that has a political orientation and that's going to censor its political opponents. So, even for people who don't go to university but just fund these things through their tax dollars, it should be quite a disappointment that they fund these institutions in the billions, and yet these institutions don't seem to have placed sufficient value on their central mission for which they are paid tax dollars.
Okay. You had mentioned the Chicago principles, and I know that in Alberta, the Premier Kenney, the former premier, had basically tasked all the universities of coming up with policies that adhere to the Chicago principles. I think this was back in 2019. And they did comply. And I know that, as I mentioned in my intro, that John Carpe has talked about the Alberta situation where he says that, the Alberta, we do have a situation where, it's been ruled upon. And just prior to this show, we were talking, you said, well, not necessarily. In some cases, yes. And I need you to sort of make that clarification for us. Has this been ruled on in Alberta? And how far do we go with the charter here and universities?
Yeah. I mean, the court has, in a few respects, found that the charter applies to universities. The most compelling case was a case called U Alberta Pro-Life versus University of Alberta, I believe. And in that case, the Court of Appeal of Alberta found that the charter applied to a government program. So this is that, they didn't say they didn't say that the university is government. They said that the university or that the charter applies to the extent that they're doing a government program. And the government program that the Court of Appeal fingered was basically facilitating free speech for students on campus, which is a pretty narrow program. You know what I mean? That's an important one. Free speech is great and all that, and important, but the Charter of Rights and Freedoms contains a number of other freedoms that might be important, including, freedom of religion. And so the way that they've narrowly defined that government program means that there's going to be a lot of government or a lot of university activity which is not going to be subject to the charter. Just in that kind of narrow vein will they be subject to the charter. And so, yeah, so I mean, it applies to the universities, yes. Doesn't apply broadly enough, I think, given, again, in Alberta, it's the same situation in BC. in Alberta, the government has their fingers all over the university. They exercise a significant degree of control. You just talked about the Chicago principles. I mean, in 2019, and I can't remember what the event was that promoted this, but the Minister of Advanced Education at that time told every university that they had to pass a free speech policy. Yeah. So he snaps his fingers, and sure enough, all the universities do what they're told, which is control. But beyond that, the universities in Alberta are also subject to something just like in BC, which in BC they call the regulatory framework. In Alberta, it's been a while since I looked at these materials, but basically it's the same concept that every year the minister is going to sit down with the university. They're going to go over what it is the university thinks it should be doing, and the minister is going to approve that. And the minister is going to make sure that basically the university is staying in its lane. I think the problem we have, though, is that, you know, the I don't know that it's a political will issue or why, but it would be a fairly simple matter, I would think, especially in Alberta, for a government to enforce those Chicago principles at universities, because what's happened at universities in Alberta is that they were asked to pass these policies. They passed the policies, and then so far as I can tell, they ignore them. So you look at the University of Lethbridge, for example, that in 2023, Francis Widdowson was invited to speak at the University of Lethbridge by a professor there on the issue of, much like my situation in BC, on the issue of the threat that wokeness poses to academic freedom. And lo and behold, the university canceled that event. And the university canceled that event paying lip service to academic freedom, to the Chicago principles. I don't know if they actually cited the Chicago principles. They paid lip service to them, but then ultimately, obviously, those principles had no purchase because they canceled the event. And furthermore said, and we're never going to host it either. So, and they didn't pretend it to be about student safety. Again, it was about psychological safety. It was about it was basically, I think the through line was it was deemed by the president of the university to be an act of reconciliation for Indigenous students on campus and for Indigenous students in the community, because Frances Widdowson is this, purported enemy of Indigenous people, even though she spent her whole life focusing on Indigenous issues. I think the upshot of that is, which I think is quite sad, is that you have Indigenous students who go to a university campus in Alberta to get a university education, and they get there and they're not provided one. They're provided, again, a university education that doesn't have any freedom of speech, that isn't going to expose them to scary ideas. That's not a university education. That's indoctrination. So if I was an Indigenous student and as an act of reconciliation, that university decided to cancel my university education, I'd be furious.
Okay. Now, you're saying the difference, though, between your case and the Alberta case is that yours is broader and includes the whole charter? Is that what you're saying here? In other words, what they really want is the whole charter, not just freedom of expression.
Right. Yeah. And it's not quite technically correct. Like in Alberta, the government program that is subject to the charter is the free speech of students on campus. So if a student, is engaged in some activity that isn't a free speech activity, and the university violates what should be charter rights that would apply there, then he or she has no charter rights, because they weren't, it wasn't the government doing this program. So if it's anything else, then it's not subject to the charter. I don't know if I'm butchering that. Did I answer your question? What was your question?
Well, I was essentially trying to figure out whether your case encapsulates the whole charter, not just the free speech elements of it. So that's what you're attempting to get them to rule on, actually, is the whole package, right? Okay.
Yeah, like I think that, in Alberta, I think it was a bit of a disappointment it's great that the Court of Appeal in Alberta at least said that the charter applies in some respect. That's a toehold, and that's great. And that's starting to get us away from these 1990s cases, because there's a recognition in Alberta, at least, that things have changed. So that's a good thing. again, the problem is that it's not more broad. And in BC and in Alberta, my suggestion is that if we're going to find that the charter applies to a program that the university is delivering for the government, why cast the program in why define it so narrowly, right? Like, what about free speech for students and faculty? What about free speech for students, faculty, and invited guests? What about free speech for anybody? What about freedom? What about freedom of assembly? Like, all of those things are really functions of the obvious government program here, right? The government, I mean, in Alberta, you could say that free speech on campus is now a government program for sure because they required all the universities to pass the Chicago Principle. But in BC and Alberta, the most obvious, glaringly obvious government program is university education. So it should be that when I engage in university education, or a faculty member is involved in university education, then the charter applies to that entire program.
Okay.
So, but I'm also saying in BC and in Alberta that let's not even be that narrow. Basically, universities are government. So let's just apply to the charter to everything.
How about for the whole country? Is this something that the Supreme Court will have to weigh in on one day? Because
yeah, I mean,
you have similar situations across the country.
Yeah, I think so. I mean, this has come up in courts of appeal across the country. They're now starting to diverge a bit on how they treat these things. The Supreme Court's job is to make sure that the law is applied evenly across the country, especially federal law like the Constitution. So, yeah, I think it behooves the court to weigh in on this, although I fear what will happen when it does.
Okay. Well, at least you'll have the day in court, or somebody will. Okay, great. Thanks so much, Glenn, for taking the time to explain this case to us. And, we're looking forward to hearing the results of this one for sure. And I have a feeling it may go on for years if it does go to the Supreme Court. But thanks a lot, and we'll speak to you again soon.
Okay, thanks very much.